To take a look at legal aspects, so we are now joined by practicing lawyer Nthabiseng Dubazana. Nthabiseng, thank you very much for your time this afternoon. So making his first court appearance, he wanted to address the court and tell the court about his concerns. A number of them, we'll get into them in a few moments, but him wanting to address the court, is that unusual for a suspect appearing?
No, it's really not unusual, especially if the accused person is unrepresented. Usually they address the court directly. But if you are represented, you should address the court through your attorney. So what would happen is that usually your attorney is giving their back to you, so they won't see that you want to address the court. So what would happen is that the court orderly would say that, sir, ma'am, your client wants to speak to you, and then you listen to what they have to say, and then you relay the message to the court. But so I don't understand why he wouldn't want to utilize the fact that he has a legal representative in the court, but what he did is not unusual.
So is it unusual for the judge to have shot that down, his request?
Well, with a legal representative, also that it's not unusual, because what the court will say is like, listen, you have a legal representative. Let me hear your concerns and your thoughts or whatever the case may be through your legal representative, because 90% of the time, the accused person is not well versed in court procedure and legal language. So whatever they're going to try and relay, it won't make sense sometimes in the court setting. So it is rather easier to have the attorney to just give the message the way it would probably land properly to the presiding officer.
This is what a portfolio committee member on Justice and Correctional Services had to say in Parliament yesterday, posing this question to the police. Let's take a look, listen.
It's very clear that there's a lot of interests and a lot of money involved here. So I am very concerned about whether Mr. Bester will be alive long enough to be questioned by the police. So I would want to know, when will the South African Police Service conduct an interview with Mr. Bester, where he is incarcerated at the present moment?
So that member of parliament had a similar concern to Thabo Bester, because he says he is scared for his life, to a point that he has not eaten for some over 24 hours, basically since his arrival in the country on the 13th of April, with the presiding judge saying that he does not have the authority over correctional services. The issue must be addressed with the relevant institutions. Is that unusual?
Actually, it is a little bit unusual. It does happen that accused persons relay this message to the court. Usually it's because perhaps there was a fight that happened, and as a result, there's a mark, so to speak, on the accused person, and the likelihood of him going back to the same prison, they might end up dead. So what usually happens is that we relay this message to the presiding officer and give the surrounding circumstances as to why. And then thereafter, the presiding officer may request that on the next occasion, or rather have a short remand, maybe a day or two, wherein the head of the correctional service or somebody who is the management of correctional services to come through and explain what would be the best position to have the accused person removed from the area where it most likely would be that they would be suffering any sort of harm. So in this situation, I'm not sure if Thabo Bester is saying specifically Kgosi Mampuru prison, he may be poisoned, or is he saying any prison that he will be placed under in South Africa, he will be poisoned. That's where the position is not clear. If he's specific to say Kgosi Mampuru prison, then it is the attorney's job to now say, since the presiding officer is refusing to make any pronouncement on this issue, he must then approach the head of prison and ensure that either he is removed from a specific area or his food is made by a specific cook within the parameters of whatever correctional services can do, and then take it from there. But if the issue is rather other prisons apart from Kgosi Mampuru, then he is out of luck in terms of what he can get in terms of food.
So do we characterize this as a hunger strike?
Yes, I think it is definitely a hunger strike, and if he goes on like this, he may in any event die due to lack of food, and he may then fail to answer the questions that the whole country and parliament wants to know. It's going to be, it's not good for the case. It's not good for him at the end of the day. So they need to find a way to compromise in this situation.
What would the consequence be if that were to be an eventuality, given that this was a request from the onset, which the presiding magistrate said, well, this is not within my parameters to actually decide on?
Unfortunately, magistrates are creatures of statute, unlike judges. So they really cannot make pronouncements on a lot of things. They can make an inquiry, find out what is happening, but they can't make a ruling which the correctional services would have to abide by. Unfortunately, that's the downside of matters being heard in the magistrate's court. If the matter does make it to the High Court before anything disastrous happens, the presiding officer, the judge, has the power to instruct correctional services to, deal with the situation in a manner that is best fitting for, everything that we need to happen in order to have the accused alive and in order to have him alive long enough to testify and give whatever evidence and information that is required. But unfortunately, the magistrates' hands are really tied because they are creatures of statute.
Thabo Bester also wished to be furnished with documents regarding his extradition to South Africa. Is it unusual that upon his first appearance since his rearrest, he has not been furnished with those details?
It's a norm. What is unusual is requesting information at this stage. It's only your first appearance. So we are in the first appearance, they're still establishing, they're putting the charge to you. That's the first thing. What your charge is you're going to face going forward. And then the dominus litis, which is the prosecutor, then informs the court what next still needs to be done, whether there's still investigations outstanding, etc., etc. And if that is the case, then the matter gets postponed for that. Yes, he will get that information when it comes to disclosure, or rather requesting the copies of the docket, and that can be a specific request if it doesn't form part of the docket, but he will get information at the end of the day. So it doesn't make sense why this request was made on the first appearance.
Nthabiseng Dubazana is a practicing lawyer. Thank you very much for your time this afternoon.